court is now in session. Please be seated.
Good morning. I know this is the fourth case on the morning docket, and I think all the formalities have been handled already. I just want to say that you have the pleasure this morning of sitting in front of what I call a grand panel, a panel of judges made up from all three grand divisions. To my left, my friend and colleague, Judge Hickson from the 6th Judicial District, and to my right, Judge Campbell from the 30th Judicial District. I'm Tim Easter from Williamson County, 21st. Let's call the last case on the morning docket, please.
Brandon Vandenberg versus State of Tennessee.
Morning, Mr. Rust.
Morning, Your Honor.
You've been busy this morning.
I have.
I've been watching you on the tube. So.
Well, I'd like to reserve 2 minutes of rebuttal time if I could.
Yes, sir.
The first thing I'd like to point out is a small but what I think is an important point in relation to the facts. On page 9 of the brief the state submitted, which I think was a fact that was taken from the 2017 opinion in Mr. Vandenberg's direct appeal, there is a statement that Mr. Vandenberg's co-defendant testified against him at trial and that he heard Mr. Vandenberg, this is Mr. McKenzie I'm referring to, heard him say that he had brought the alleged victim there in order for this group of people to have sex with them. That is the PG version of what was said allegedly. And then the facts, both in the opinion as well as in the state's facts in this brief, go on to say that the videos that were submitted as evidence in the trial confirm this or corroborate this. I went back and I checked. Those are exhibits 41A, B, and C of the original trial court record, which is M 2017-1882. Those videotapes do not contain Mr. Vandenberg saying those statements. So I just wanted to point out to the court that there is not a corroboration for Mr. McKenzie's accusation there in the recorded evidence that was submitted at trial. And since criminal responsibility was the basis for the state's conviction in this matter, I think that any kind of corroboration to his accusation that Mr. Vandenberg stated this was the purpose for having him brought the girl to the room that night is an important distinction to make. What I wanted to focus my
that doesn't impact any of your issues on this post-conviction.
Not particularly, no. Other than again, the state had pointed that out, and again, if the basic theory for the state is that Mr. Vandenberg supplied this girl for this purpose, and the court not having necessarily delved into the 25 volumes, I think, in the 4 bankers boxes of the previous case, I simply wanted to point out that is not borne out by what was in the record from the trial. I do believe that the state made all of that a portion of the record for this proceeding in the post-conviction, so it should properly be in the record for this case as well. What I wanted to discuss was why and how Mr. Troy Bolin, who was lead counsel for Mr. Vandenberg in his second trial, was both deficient in his performance and how this prejudiced Mr. Vandenberg, particularly in reference to Dr. Sidney Alexander. I know the court has probably reviewed the briefs, but just to recap, this was a second trial for Mr. Vandenberg. In the first trial, he had a co-defendant, Mr. Beatty, that was tried at the same time. Mr. Beatty had procured an expert as to the effects of intoxication on the ability to form intent. For various reasons, Mr. Beatty was not tried at on the second instance with Mr. Vandenberg. And though it's not entirely clear as to why, whenever that severance took place in the spring or early part of 2016, Mr. Vandenberg had not procured any expert of his own to opine to the jury about this issue. Mr. Bolin, who was his lead counsel, there had been a scheduling order that had been put down in 2015 that experts had to be declared, I believe, by December of 2015. They declared no expert. And essentially, they being the Vandenberg defense team, were stuck without an expert to discuss how Mr. Vandenberg could not have formed intent on that evening in order to be criminally responsible for the acts of his co-defendants. This was deficient on Mr. Bolin's part from start to finish. The trial court, and the post-conviction court, I should say, gets to, and I'll get to that in a minute, claims that lack of notice or failure to have procured this particular witness in a timely manner is not the reason that they excluded Dr. Alexander, but I think it's important to lay out the full factual scenario. The failure to have an expert available and designated when that expert is the primary linchpin of your defense, I think is almost per se deficient on part of your trial attorney. It is uncontroverted that Dr. Alexander was not engaged until May of 2016. The trial took place in the middle of June of 2016. And he was not heard at all by the trial court until Mr. Boland filed a motion to reconsider the trial court's exclusion of Dr. Alexander, which had already taken place at that point. The motion to reconsider, the basis was that Dr. Alexander could potentially be used as a rebuttal witness against the state's proof at trial. This is, quite frankly, trying to bring through the back door what didn't come through the front. How that would work was unclear, but it made no difference because the trial court did not allow Dr. Alexander to testify in front of the jury as to any purpose. Now, to take a small step back, Dr. Alexander is a trained psychologist. He's not an intoxication expert. He never purported to be an intoxication expert. He wasn't tendered to the court at any point as an intoxication expert. Intoxication was part of his analysis because what he was going to opine about for Mr. Vandenberg was that if one was intoxicated, their ability to form intent, particularly in a young person's mind, I believe Mr. Vandenberg is about 20 years old at this time, would be severely impaired. And that was his ultimate medical conclusion, which he got to in the post-conviction testimony. Mr. Boland's handling of the matter, putting aside for a second that he never got this person designated as an expert in the first place, at the motion to reconsider, the trial court left with the impression, one, that Dr. Alexander's purpose was to talk about the intoxication of Mr. Vandenberg, and that was what his expertise is in. Two, that he had never spoken with Mr. Vandenberg to form his opinion. And three, that he wasn't qualified to opine about intoxication because he didn't have that expertise. All of this, I would say, goes to the deficiency of Mr. Boland. But when we had the post-conviction hearing last year, Dr. Alexander did testify, and he testified in front of the same trial court judge that heard the trial and should have cleared up a lot of these misconceptions that Mr. Boland left the trial court with. Dr. Alexander testified that he had spoken with Mr. Vandenberg for 3 or 4 hours in order to help form his opinion, as well as the fact that he'd reviewed the state's discovery, and that was what the basis of his opinion was. He also stated that while Mr. Vandenberg said he thought he had over 25 drinks, it didn't make a lot of difference whether that was high or low to his ultimate medical conclusion. So the level of intoxication was not important. It wasn't what he was there to testify about. He, Dr. Alexander, was given the impression that he was there to talk about how intoxication affects the brain and the ability to form intent and decision-making and the impairment that causes, not what the blood alcohol level was of Brandon Vandenberg. Mr. Randall Reagan, who is the second chair counsel in this case, testified at the order of protection hearing. I'm sorry.
Last case.
Last case. Well, I have OP written next to it, but it was for his opinion, not for it. Anyway, Mr. Reagan was second chair counsel, and he testified at the post-conviction hearing. He made it clear that Mr. Boland was the one in charge, that he worked for him, that Mr. Boland was the one who handled Dr. Alexander's testimony, who came up with the strategies, both to use the idea that intoxication was their defense, as well as the execution of that strategy. Mr. Reagan described Dr. Alexander's testimony, had it been available to the jury, as very important, and that it would have substantially aided Mr. Vandenberg in his chosen defense. But
the jury heard all kind of testimony about the level of intoxication that was being exhibited by your client.
That's correct.
There was video.
There was audio.
There were witnesses who testified about how drunk he was.
That's exactly right, which is why it's kind of baffling that the trial court and post-conviction court thought that they needed an expert to talk about how drunk he was. Everyone in this case knew he was drunk. The state knew he was drunk. He said he was drunk. The audio tape, the videotape, the testimony from his friend who he had left voice messages to that were incoherent. That wasn't the issue, and that wasn't why Dr. Alexander was important. He was important to explain to the jury how that level of intoxication could have affected his ability to commit the criminal offense that he's charged with.
Was he qualified to do that under the best case scenario for Mr. Vandenberg? I mean, we're talking about a psychiatrist who's not certified in toxicology or pharmacology. He admits that. Says he's never been tendered or received as an expert in toxicology. You had the expert in the other trial, Mr. Beatty's trial, I believe, who was a pharmacologist and who was allowed to testify. Was Dr. Alexander the correct person to be using here in the first place?
I think that he was. I don't think that the trial court understood that. I agree. The trial court seemed fixated that in order to talk about how a drunk person behaves, you have to be able to say they're drunk. I think it was presumed that Mr. Vandenberg was drunk for the exact reasons that Judge Easter talked about, but that doesn't help a jury to say, well, on a legal basis, does that prevent him from forming intent or not? Well, if you have a psychologist, psychiatrist who can talk about the effects of alcohol or intoxication on the brain and the way that it affects the person's ability to form intent, I think that's exactly the witness that was needed. Why the trial court failed to understand that, I don't know. I can say, based on Mr. Boland's performance and how he attempted to have Dr. Alexander qualified, was not helpful. In fact, it seems to have been counterproductive. And since we are here on an ineffective assistance claim primarily, I think that's the more pertinent point. But yes, to answer your question, I think he was the exact correct person to talk about it. He said that he'd been qualified 30 or 40 other times in other cases to talk about psychological issues. And we didn't get into exactly how many of those were in this exact scenario. But yes, I think how the person, a witness, an expert like that would have aided the jury would have been for the jury to take it the next step and say, well, everybody thinks this guy was drunk. What difference does that make? Which would be a natural question for a juror to ask. Does that mean he's not guilty because he's drunk? Well, no, not necessarily. So that's exactly why they wanted to have Dr. Alexander there, and that's why he was the right witness rather than an intoxication expert to talk about how drunk he was.
I know, I'm sorry.
No,
Cal.
go ahead.
A lot of, when we were at this juncture looking at expert testimony that was not admitted at trial, then at the post-conviction, the petitioner brings in an expert who says this is why this testimony would have been beneficial. At the evidentiary hearing, did anyone other than Dr. Alexander testify about the expert testimony that qualified as a toxicologist expert? Did anyone testify at the post-conviction?
At the post-conviction? No, there wasn't a toxicology expert at the post-conviction, no. Again, our effort was to show why Mr. Boland's failure to have Dr. Alexander tendered as a psychological expert was so damaging. Again, I don't think the state ever claimed that Mr. Vandenberg wasn't drunk. That didn't strike me from having not participated but know the trial fairly intimately at this point. That was a non-issue. I mean, again, as you stated, he had videotape of coming into the surveillance tape. There was the videos from inside of when he's incoherently talking about various things. There's the audio tapes to Mr. Quinzio, and he said he'd never heard him that intoxicated. It didn't make any sense what he was talking about. So again, the upshot of this was not to say that he was drunk. It was to say that because he was drunk, he couldn't have formed the intent to commit the crime. And so how that ball got dropped is the entire point of our argument on this issue. To turn briefly to the trial court's or the post-conviction court's order as to this issue, it is very sparse. It's contained in the entirety of my brief, but a couple of points that I wanted to make. The opinion or the order says that while the defense, the post-conviction defense, alleged that Dr. Alexander wasn't allowed to essentially make his case to the PCR court, the court says he had the opportunity to express his opinion on the effects of alcohol. However, he did not do so. And this is in reference to the 2016 hearing, this motion to reconsider. Well, That's as much as saying that Mr. Boland didn't do his job. It isn't Dr. Alexander's job to answer questions that are not asked, talk about topics that are not the subject of the hearing. Dr. Alexander testified at the post-conviction hearing. His belief that going into the 2016 hearing was he was going to opine about the issues I've already talked about, that he thought he was going to talk about Mr. Vandenberg's mental state and how intoxication plays into that mental state, not talk about how drunk he was or wasn't, how many drinks he did or didn't have. It was Mr. Boland who chose that tact, who asked the wrong questions. So if the trial court's left with the impression that Dr. Alexander had the opportunity to do this in 2016 but didn't, again, it as much as admits that Mr. Boland wasn't doing his job, that he should have asked those questions to elicit that testimony.
But didn't Dr. Alexander testify in 2016 that Mr. Vandenberg would have been unable to form intent given his level of intoxication? And isn't that really what the defense was shooting for at the time?
Well, that's what he said to the trial court judge, but he wasn't allowed to say it to the jury because ultimately the trial court determined that, one, he was not an intoxication expert, so he was not properly tendered to the court, and two, that his testimony couldn't assist the trier of fact. So that was his ultimate...
We're talking about counsel's performance, though, not how the trial court ruled back then. Counsel elicited that testimony that he would be unable to form the mens rea of intent due to his intoxication.
Well, I'd have to go back and look at the transcript again. I don't recall that exact, but I don't remember whether he was asked, do you have a medical opinion about the ultimate outcome? I think he probably was. But at the end of the day, the reason that the trial court purportedly excluded him was because he was asking the wrong questions. I mean, again, the trial court was left with the impression that he was being tendered as an expert in something he's not an expert in, and it was not the intent of the court to, the defense to tender him as an expert in that field.
Well, this is from Dr. Alexander's direct examination, and I'm referring to this court's opinion at the very end of page 30. Dr. Alexander explained that the defendant, quote, would not have been cognizant enough to be able to form intent or to have more than first-order thinking. And that was elicited on direct examination by Mr. Boland, I'm presuming, at that point. So is that not evidence there in the record that Mr. Boland did, in fact, put that ultimate opinion in front of the trial court, and it was the trial court who rejected it?
Well, I think that that would be proof that he elicited that testimony. But again, the trial court, based on his approach to having this party tendered as a witness, was left with the impression that this was about intoxication, not about intent. So I do put that at Mr. Boland's feet. If the trial court is left with the incorrect expertise, I mean, the impression that this person is here for a different reason than they're actually there. He could have opined about a lot of things, but if he's being tendered in the trial court's opinion, based on what Mr. Boland has said as an intoxication expert, a toxicology expert, then I don't think it matters very much. You know, he could opine about whether Mr. Vandenberg was able to form intent or not, but the trial court is thinking, based on Mr. Boland's assertions, I'm here to determine whether he can say how drunk Mr. Vandenberg was or not, and I don't think that he can. So whether he thinks he can form intent or not, that's not what I'm being asked to decide because his lawyer hasn't put that case in front of me, if I'm thinking in the trial court in 2016. So I would disagree with that conclusion, if that's your conclusion, Your Honor. But briefly, I think it kind of circles back the post-conviction court's order about this issue, again, saying that it wasn't on a notice basis, but that it was on an expertise basis. And despite the testimony, which the court can review, of Dr. Alexander in the post-conviction court's still under the impression this is about intoxication even in 2022, despite him saying that's not what he was retained for, despite him saying, Mr. Reagan saying that's not what I thought he was retained for, despite Mr. Vandenberg saying that's not what he was retained for. The trial court still believes this is about intoxication, and therefore that was the reason it didn't find that there was ineffectiveness. So I know I've run into my rebuttal time here, but the order from the trial court on this issue does not address the issues that were raised. And so I would respectfully say that this is woefully deficient performance on Mr. Boland's part, and that it was highly prejudicial to Mr. Vandenberg, and it meets both prongs of the Strickland test.
Thank you, sir. Ms. Gilbert?
May it please the court, I'm Alicia Gilbert on behalf of the state of Tennessee. This court should affirm the denial of post-conviction relief. Petitioner presents a variety of claims requesting post-conviction relief, but I would like to focus my time today on petitioner's ineffective assistance of counsel claims, starting with the one he focused on, which is the ineffective assistance of counsel claims surrounding Dr. Alexander, the expert witness that the trial court disqualified. As this court is well aware, to show ineffective assistance of counsel, petitioner bears the burden to show both deficient performance and prejudice. The easiest way for this court to resolve this question is on the prejudice prong, and this is what the post-conviction court relied on as well. Petitioner wanted Dr. Alexander to testify to support his defense that he was too intoxicated to be criminally responsible for the rape of the victim. But petitioner cannot show prejudice here due to the overwhelming evidence of his criminal responsibility in this case. First, petitioner initiated getting the victim to the location where the offense occurred. Petitioner asked his co-defendants to assist him in taking the victim, who was unconscious at the time, where they were parked on campus, to a semi-private dorm room. Second, there were text message exchanges between the petitioner and his friends on the night of the offense, where he was sending videos and photographs of the offense while it was still occurring, and his friends were reacting to what they saw by referencing the term rape. And petitioner responds by asking his friends to delete the entire thread. Third, in the video evidence of the offense, petitioner can be heard actively encouraging the co-defendants. I won't quote the language used by petitioner today as I do in my briefing, but suffice it to say that these statements were directing or encouraging the co-defendants along in the rape of the victim. Fourth, petitioner covered up his head in the hall surveillance cameras before moving the victim after the offense occurred. Fifth, petitioner assured the co-defendants after the offense that everything would be okay, and he flushed the condoms he had previously passed out to the co-defendants before the offense occurred down the toilet after the offense. Finally, petitioner sought to have unprotected sex with the victim the next day, again to cover up evidence of the offense. With actual video and photographic evidence of the offense, as well as testimony from those present, petitioner cannot show that even if the jury had heard Dr. Alexander's testimony, that there was a reasonable probability that the outcome would be different. Nor can petitioner show deficient performance by counsel at that pretrial hearing. While petitioner first alleges deficient performance related to counsel missing the pretrial disclosure deadline to disclose his proposed experts, petitioner runs into a problem here because the trial court does not ultimately exclude Dr. Alexander due to this missed deadline. In other words, any potential deficiency in counsel's performance due to the missed deadline was essentially cured because counsel filed a motion to reconsider, and the trial court heard Dr. Alexander's proposed testimony at that pretrial hearing before ruling on the motion to reconsider. And unrelated to the missed deadline, the trial court ultimately excludes Dr. Alexander because he wasn't a qualified expert in toxicology and because his report lacks trustworthiness. So petitioner can't show prejudice based on the missed deadline alone. So he then alleges that counsel was deficient by not soliciting the proper testimony from Dr. Alexander at this pretrial hearing that would have led to the trial court determining that Dr. Alexander was qualified to testify at trial. But petitioner can't show deficient performance by counsel at the pretrial hearing because the record indicates that the testimony that Dr. Alexander provided at this pretrial hearing is almost identical to what Dr. Alexander provided to the post-conviction court at the post-conviction hearing. At the post-conviction hearing, Dr. Alexander said that he wanted to testify at trial about what effects a particular blood alcohol level would have had on petitioner's brain and his ability to form the intent to commit the offense. He admitted that while he didn't have to know petitioner's exact blood alcohol level, it certainly needed to be close enough because it affected the symptoms that that petitioner would portray. Similarly, at the pretrial hearing before the trial judge, Dr. Alexander testified that assuming petitioner's blood alcohol level was about 0.22, combined with his prior medical history and his drinking history, he would have displayed symptoms of being uncoordinated, unbalanced. He would have had slurred speech, difficulty making decisions, etc. And in Dr. Alexander's opinion, petitioner wouldn't have been cognizant enough to form the intent to commit the offense or have more than first order thinking. In other words, the record suggests that the decision by the trial judge to exclude Dr. Alexander's testimony did not arise from deficient performance by counsel at this pretrial hearing. Dr. Alexander's testimony was the same at the post-conviction hearing. He didn't add anything new. Rather, the record suggests that this was simply an exercise of the trial court's valid discretion to exclude an expert witness who was not qualified and whose testimony was not trustworthy. The trial court found that expertise in toxicology was critically important to Dr. Alexander's testimony, even though Dr. Alexander, was a psychiatrist and would have been, presumably qualified to testify as to psychiatry. Opining on what petitioner's estimated blood alcohol level would have been was a key component of his testimony, even as it pertained to psychiatry. Dr. Alexander even admits this at the post-conviction hearing. Yet Dr. Alexander did not have specialized knowledge or training in toxicology or pharmacology. He was a psychiatrist. The trial court also found that Dr. Alexander's proposed testimony was not trustworthy, and his report was essentially a letter that was based largely off of information that he had received from counsel. And he admits to submitting his report before he first spoke to petitioner. Finally, to the extent that counsel opposite is arguing that counsel was deficient for not having a toxicology expert at all, this fails because petitioner doesn't present a toxicologist at the post-conviction hearing. And we can't compare how petitioner's trial would have turned out to how Beatty's trial would have turned out, because Beatty did have a toxicologist. We simply don't know what a valid expert in toxicology would have opined about as to petitioner's ability to form the intent in this case. The post-conviction court therefore correctly denied post-conviction relief as to petitioner's ineffective assistance of counsel claims surrounding Dr. Alexander. Petitioner's remaining ineffective assistance of counsel claims also fail. Let's briefly talk about his claim that counsel was ineffective for not convincing the trial court to admit testimony or evidence of co-defendant's sexual encounter with an underage female from the night before. I refer to this as the Jane Doe evidence in my brief. The trial court excluded the Jane Doe evidence as irrelevant because it involved a different event, an encounter with a different young woman, and petitioner wasn't present. Petitioner can't link any of the trial court's decision to deficient performance by his counsel because any of the alternative theories of admissibility that he raises in his brief would have first depended on this evidence's relevance. His counsel challenged the decision on multiple fronts. They filed a motion to allow the prior bad acts and conduct of the co-defendants. They argued that this evidence should be permitted under Rules 404, 608, and Rules 616 of the Tennessee Rules of Evidence. In other words, petitioner simply cannot show deficient performance by his counsel, nor can he show prejudice, again, due to the overwhelming evidence of petitioner's criminal responsibility in this case. Finally, petitioner's claim that counsel was ineffective for not convincing the trial court to admit the voicemail he left on his friend's phone also fails. The record indicates that counsel did, in fact, argue that the voicemail was not self-serving and that it was being offered for the purpose of showing that petitioner was intoxicated. So petitioner cannot show deficient performance, nor can he show prejudice for two reasons. First, this voicemail wouldn't have been particularly persuasive to the jury because on the voicemail, he seems to make some sort of acknowledgement of his awareness that he could get in trouble from his conduct on the night of the offense. Yet petitioner wanted to use this voicemail to show that he was too intoxicated to be criminally responsible. Second, in addition to the testimony that petitioner was intoxicated on the night of the offense, the jury saw direct or firsthand evidence of petitioner's intoxication. In the video evidence, you can see petitioner stumbling, you can see him struggling to carry the victim, you can hear him talking and laughing, but the jury still convicted him, again, due to the overwhelming evidence of his criminal responsibility. In other words, there was so much evidence of his criminal responsibility that, even though there was evidence that petitioner was intoxicated, there's just overwhelming evidence that he was not too intoxicated to have the requisite intent in this case.
Ms. Gilbert, let me ask you this question, and that has to do with this issue regarding the voicemails. On direct appeal, in our opinion, I believe we said it was error for the court not to have admitted those voicemails, correct? But we found it to be harmless error.
Yes. So on direct appeal, the court found that this court found that the trial court erred by excluding the voicemail on hearsay grounds, but found that the error was harmless. And to the extent that it factors in at the post-conviction stage, I think the fact that this court found this to be a harmless error goes to the prejudice prong here.
Well, that's what I was going to ask you about. And from the position of the state, how do we weigh where this court has previously found something to be harmless based on overwhelming otherwise evidence against how he was prejudiced? I mean, does that just automatically close the door to that issue, that we found that there was overwhelming evidence so that the admission or the failure to admit it was a harmless error? Does that just close the door to the petitioner raising on appeal then the prejudice piece? I mean, does that just trump everything to say that there was no prejudice because it was a harmless error?
I don't think it necessarily trumps it. I think that it is instructive to this court. Perhaps this court could, it's obviously a different issue, but perhaps this court could acknowledge that because it was harmless error, that suggests here too that it wouldn't have made a meaningful outcome to the jury if they had considered the voicemail. But this court doesn't have to reach that question because there's an alternate way of showing no prejudice here, and that's simply that the voicemail itself, petitioner, I'm not going to quote exactly what he says, but petitioner basically seems to acknowledge his awareness that he knew he could get in trouble from his conduct on the night of the offense. So it wouldn't have been persuasive to the jury even if they had heard it. It wouldn't have made a difference in the outcome of this case. So this court doesn't really have to reach that question to find that there was no prejudice as to that issue. Petitioner's remaining claims for post-conviction relief are barred because they were the exact same claims that he presented to this court on direct appeal, so I'd like to rest on my brief as to those. So unless this court has any other questions, I would request that this court affirm the denial of post-conviction relief. Thank you.
Thank you, ma'am. Mr. Russ?
I know I don't have very much time, Your Honor, so I'll try to be as quick as I can. First of all, by the trial court's reasoning here, a toxicology expert can talk about psychology, but a psychology expert can't talk about psychology because they're not a toxicologist. That's it in a nutshell. The entire reference to the Beatty trial was that the same judge in the same set of facts did permit an expert as to toxicology. So again, clearly for some reason that was what the trial court thought should have been admitted. I disagree, and regardless of whether that's what the trial court thought should have been relevant to the jury, that wasn't Mr. Vandenberg's chosen defense, and I think he presented adequate evidence as to why. The post-conviction testimony from Dr. Alexander was different. The conclusion was the same because apparently the trial court was fixated on this toxicology issue. Dr. Alexander filled in the blanks that were apparently, according to the trial court's denial order from 2016, he was under the impression he never talked to Mr. Vandenberg. He had for hours. That was explained. He was under the impression, the trial court, that he was there to talk about toxicology. He explained that was not what I was retained by Mr. Boland to do. That's not what I thought I was going to do. It wasn't until I got on the stand they started asking me these questions. I'm not an expert in that. So that was the purpose of that. I would say that what the state's attorney points to as to indications that Mr. Vandenberg did have criminal responsibility, having sex with the woman the next day, you know, trying to send text messages to various people, that is not an indication that he provided this person for the purpose of those folks to do what they did. And lastly, I will say, it's on page 22 of my brief, an email that was trial exhibit, post-conviction exhibit number 2 from Mr. Boland, wherein he says, if this court is saying we cannot call Dr. Alexander, then I am stating that I have provided ineffective assistance of counsel. I think that sums it up. So,
Thank you, sir. Any additional questions? Anything else? Anything else, John?
Nope.
Thank you both for fine arguments and good briefs. And we're going to be in recess to 1:30, is that correct? We'll resume at 1:30 with the afternoon docket.
All rise.